So we will go ahead and call that case, People of the State of Michigan versus Jemison.
May it please this most honorable court, Kristen Lavoie from the State Appellate Defender Office on behalf of Mr. Jemison. I will keep track of my own time, but would like to reserve 2 minutes for rebuttal. This entire case was about DNA. It was the only evidence tying Mr. Jemison to these charges. Yet the prosecution chose to call the DNA expert by video over objection. The Court of Appeals wrongly found that this constitutional violation was allowed, wrongly relying on Maryland versus Craig, even though there was a violation of the court rule, saying that cost and convenience were a sufficient enough public policy interest to violate the Confrontation Clause. This court should reverse and find that Craig should be read narrowly, applying only to children who would suffer trauma from testifying, and if read broadly, applying to other witnesses, that cost and convenience are not a sufficient public policy interest to infringe upon constitutional protections. This error was not harmless. This error was not harmless beyond a reasonable doubt. We would ask the court to reverse, and I would welcome questions at this time. Mr. Jemison was denied his confrontation rights. One key pillar of confrontation involves face-to-face confrontation, and that is what's missing here. Basically, what the Court of Appeals opinion states is that even though this one key part of the protections were missing, that is still sufficient. Even under Craig, this would not be allowed. There's an argument that Craig should not be applied. Looking at the language of Crawford itself, extending confrontation, if anything, you would basically be in a situation where the language in Crawford is either dicta or should not apply anymore. So to begin with, Craig itself the vitality of Craig itself is in question, and I do believe that the Amicus brief does address this very well.
Counsel, I was confused about how the Court of Appeals could address this question without discussing Crawford, but it doesn't seem that the parties raised it in the Court of Appeals. Why not?
This was raised as a constitutional argument in the Court of Appeals. It was raised twofold. First, that there was a violation of the court rule, and that second, this was a constitutional...
No, I know there was the constitutional issue was raised, but I didn't see in your briefing any reference to Crawford.
I do believe that Crawford was cited, and there was an argument on confrontation and the face-to-face the aspect of this.
Okay, maybe I'm incorrect.
Yeah. And here what we have, it wasn't even that clear on the record as to the nature and the reason for bringing this witness by video. There was an argument that this witness was in Salt Lake City, and so we're left with a trial court making a decision that because of this distance or the inconvenience of it, that this would be allowed. And this undermines the requirement that this be an important public policy interest. Looking at all of the cases from other states, from the federal circuit, I was only able to find one case, and that was the Missoula case, that said that cost and convenience are an important public policy interest that would justify the infringement of the constitutional protections. And so what we're left with is a defendant that's being punished because of a strategy call by the government that failed to test these kits, the government that chose to outsource this job to another state for testing, knowing full well that the prosecution is aware of the court rules and what would be required if this would go to trial, understanding the costs and benefits of that choice, and now the defendant is left with being faced by virtual confrontation, which was not sufficient here.
What's the test for the court rule violation, which obviously everyone concedes? I mean, I understand the constitutional test for how to think about whether it's harmless, but how do we apply how do you think about the test for thinking about harmlessness in the context of the court rule?
I think that the court can apply the harmlessness test the same in looking at the context of the evidence that was presented without this particular witness. And even looking at the context of this witness testifying by video, I think that there's an harm argument there as well. There's no scientific basis to show that the video testimony would be the same as in court. We have, there's been lots of studies on this, but looking at the context of harm, even in a violation of the court rule, the court can make the analysis the same way. What changes is this harmless beyond a reasonable doubt standard versus, the Luckety test. And so I think that is the difference in the analysis. But I think you should still look at the evidence and the context of harm in the same context. And this error was not harmless beyond a reasonable doubt. The prosecution in their brief, and we certainly made an argument that these arguments were waived or abandoned on appeal. But even for sake of argument, the prosecution relies on the fact that there was a notice filed in the middle of a discovery package that says that we intend to bring these reports in without the expert. The attorney objected by email, albeit by email and not in writing, indicating that he was not going to agree to this. They go to court. The prosecution indicates that they are in fact going to call this witness by video. At this point, the attorney no longer has the need to file the written objection. So the prosecution here makes a strategy call to call this witness, understanding that this is to explain DNA evidence. They make a strategy call not to raise this in the Court of Appeals, and they make a strategy call not to raise it originally in this court. And now the prosecution should be left with their strategy decision that this witness was necessary. And so the report itself would not have been admissible. Had Judge Viviano said, okay, this report is admissible under 6.202, but I'm not going to let this witness testify by video, I mean, we'd be in a different position if the prosecution chose not to call them. But once the prosecution insists that I'm going to call this witness, albeit by video, the attorney makes his objection and knows that this witness is coming in, he no longer has the need to file this written objection. So, had it been the other way around, he might have said, can I have an adjournment? I'd like to file a written objection. I thought this would be enough with an email. It was hidden in a discovery package. And, that would be good cause to adjourn the writing requirement. Just like in the Supreme Court in Kimna case, belatedly raising this written requirement, to sufficiently comply with the rules undermines the protection here for the constitutional protection.
Counsel, I have a question. Just from a pragmatic perspective, why is it outcome determinative that the person was testifying by video and not in person? Explain to me, what makes that so that it's impactful on the jury?
Well, for starters, looking at the constitutional analysis, we look at the evidence without the witness testifying at all. So taking the evidence that's in front of the jury without Cutler's testimony. Without Cutler's testimony, we argue that this report would not have been admissible. Mm-hmm. We're left with a complainant indicating that she had been assaulted. She was not able to identify her attacker. There was no statements made. I know the prosecution referenced that there was some argument about this being a consent defense, but that was only done so once the DNA evidence was going to come in. And frankly, that was just argument. There was no evidence presented about that. So looking at the evidence in front of the jury without Cutler's testimony, there just wasn't enough. And even looking at Cutler's testimony itself, what did that offer beyond the report? So let's say the report comes in, but not his testimony. Mm-hmm. His testimony also provided evidence that the way the DNA could be analyzed would corroborate the complaining witness testimony that she'd had consensual sex with someone wearing a condom and then this assault. Mm-hmm. So his testimony above the report also provided additional evidence that would show this is not harmless beyond a reasonable doubt. As far as him testifying by video mm-hmm. or in person, I think this goes to the nature of our founders' concerns with confrontation, that we're not looking at the reliability of the individual evidence, but the process of the reliability. Mm-hmm. And there are just general concerns about witnesses testifying by video compared to someone testifying live. So, for example, a witness could be looking off camera. I mean, even with experts, the credibility and knowledge of an expert is very important, and we would have no way to show that they weren't reviewing a treatise off screen. There's generally a lot of concerns that we just don't have enough data to support that this should be allowed across the board. So even applying the Craig test, it's important to think about what was actually necessary to further this important public policy interest. I mean, there was other options the prosecution could have done. They could have sent the kit to testing in state. They could have requested an adjournment for the expert to be available. But instead, they went forward with this process that violated Mr. Jemison's confrontation rights when there wasn't an important public policy interest. If the court has no further questions, I would reserve the remainder of my time for rebuttal.
Thank you.
May it please the court, my name is Richard Friedman, appearing as Amicus, and I appreciate the opportunity to do so in person. I welcome questions at any time, and I'd like to reserve 2 minutes for rebuttal.
Okay, so what does a court do in a case where a court that doesn't have the authority to overrule Craig, even if we think it was basically abrogated or seems like they're just ignoring it? Mm. How do you write an opinion in a case like this where it's a Craigy issue?
Sure.
What do you do? What do you do with Craig if you're
well? First,
like
first you say, well, we have to assume for purposes of this case that Craig is good law because we can't overrule it.
That sentence I got.
Yeah, right.
just-
And I wouldn't mind if there's another sentence saying it seems utterly inconsistent with the categorical approach to the Confrontation Clause adopted by Crawford. But even assuming that Craig remains standing, it shouldn't extend beyond children and perhaps vulnerable adult witnesses to the general run of adult witnesses. I mean, that's just the context of Craig. And given Crawford and given the clear contravention in approach, I think that's really appropriate. And frankly, the Court of Appeals opinion made me think I was in some kind of time warp because it just didn't take into account the fact of the Crawford transformation. So confrontation rights, a central part of our criminal procedure, governs the way an accused gives, witnesses against an accused give testimony. And we can think of the right apart from the oath as having three parts. The right to cross-examine is obviously critical. An aspect even older is the right of the accused to be face-to-face with adverse witnesses. Those aspects can't be overcome by showing the need for the testimony. The third aspect is the right to have the witness give testimony in the presence of the trier of fact. And that aspect is conditional in the sense that if it's not reasonably possible to do so at trial, then prior testimony taken in the presence of the accused and subject to cross will suffice. Now, at this point, we can't have confidence that virtual testimony of the type conducted here is equivalent to live in-person testimony along any of those three dimensions. It may impair the ability of the cross-examiner. It may not have the same solemnizing effect on the witness as face-to-face confrontation, and it may limit the ability of the trier to assess the witness's testimony. And in my brief, I raised some reasons for concern. Perhaps with more technological improvement and more scientific research, we'll reach a point where we can say that virtual confrontation can be made the equivalent of genuine confrontation, but we're not there yet, and the state makes no attempt to show that we are. And I think it's clearly the burden of the state to show if they're going to change what has been done for half a millennium, well, more than that in other systems, that this is as good. So I believe the court shouldn't yet start down the road of allowing remote testimony over objection by prosecution witnesses. But if it does, it should start slowly in two senses. One is that remote testimony should only be allowed pursuant to a protocol approved by the court addressing such matters as the quality of transmission on both ends, the size of the screen, lighting, the camera view, would there really be eye-to-eye confrontation, and the presence of others in the room where the witness testifies. There was nothing of the sort done in this case. Now, there is a protocol pursuant to the court rule that the State Court Administrative Office has adopted, and I think it wasn't drafted for the situation in which a prosecution witness is going to testify over objection. So I think it's rather vague in some of these respects. But 2 points: the judge didn't pay any attention to the protocol at all, didn't make any of the findings that the protocol requires, and that protocol specifically says Skype is not acceptable. So,
but is it your view that protocol would be sufficient?
I don't think
if
so.
It had been followed. Okay.
I don't think so. I think there's got to be a good deal more detail. I don't have any complaint about that protocol for the purposes for which it was designed. But if the court were to say, oh, in some cases we're going to allow remote testimony over objection in a criminal case, then I think more detail would be necessary.
But to follow up, are the standards the appropriate standards for when to depart from the traditional cross-examination process?
Well, that protocol doesn't provide any standards at all, because it applies in other types of proceeding and in criminal trials by consent. So I think that's the other aspect in which I think the court needs to go.
Maybe I'm missing something here, but it says that the denial of confrontation must be necessary to further an important public policy, and it's permitted only where the reliability of the testimony is otherwise ensured. Isn't that what Craig stands for?
Well, that's what Craig stands for in the context of child witnesses. And I'm saying,
You think it's limit? Well,
Yeah.
Wasn't Craig simply a case that stood for the proposition that trying to protect a young child from having to face a person who had allegedly abused her was one such public policy that could satisfy the standards of Craig?
Yes, and Craig was written in the era of Ohio v. Roberts, and that's been totally repudiated. The whole intellectual underpinnings of Craig have been repudiated. So I think it's inappropriate for this court to expand on Craig to a situation.
I thought you were focusing in response to Chief Justice McCormick upon Craig in particular.
Yeah, this court can't overrule Craig. I just think it has nothing to do with this case. Okay. But if the court is going to allow remote testimony over objection, I think it should only be in compelling cases. And I think those are quite rare because ordinarily, even if the witness cannot be brought to court, counsel and the accused can be brought to the witness and a deposition can be held. One case, the Yates case, cited on page 11 of my brief from the 11th Circuit, the court says, well, they should have gone to Australia, brought the defendant to Australia to do a deposition. This case is the reverse of compelling. Here the state, to compensate for its own errors, has chosen to farm a crucial investigation function to a lab out of state, and a witness from that lab could easily have traveled from Utah to Michigan to give testimony that results in a long term of incarceration if only the state were willing or compelled to pay. I'll now pass on, if it's okay with the court, to harmless error. Constitutional error can be disregarded only if it's beyond a reasonable doubt that it didn't affect the verdict. If just the rule violation were at play, a lesser standard would apply. But in either event, it's clear that the error was harmful because the harmless error standard in this context must be applied in a particular way. As Coy makes clear, a reviewing court can't speculate as to what would have happened if the accused had been afforded the confrontation right with respect to the given witness. That's just too speculative. Rather, the court must effectively wipe out that witness's statement altogether and ask what the effect would have been. In this case, I think it's clear that Cutler's testimony was indispensable to the prosecution. This is a cold hit case, which depends on matching profiles from two labs, and Cutler's testimony was the means by which the prosecution provided the finding from one of those labs. There would have been no case without it. It would have been like one hand clapping.
Now, counsel.
Yes.
You don't believe that the harmfulness of what took place here was attenuated by the fact that the expert's written report was also submitted into evidence, and at least pursuant to the rules, there was no objection within the requisite period. You don't think that attenuates the harmfulness of what occurred here because you questioned the propriety of those reports having been admitted in the first place? Is that correct? That's
the first point. Yes, I think that the report probably would not have been admitted without the testimony, and the
was it conditioned upon the testimony or somehow connected with the testimony?
I'm sorry, and I think the record is unfortunately unclear. I've had trouble figuring it out, but what is clear is that the prosecuting attorney said that they would bring in Cutler's testimony, oral testimony, only if necessary. So they clearly believed that it was necessary.
Well, what do you make of the fact that there was testimony as to the context of Cutler's report even before he testified at trial? You still see it being conditioned in some way upon his eventual and ultimate testimony. Is that
yes,
right?
Yes, somebody from the lab has to testify to the lab's results. I think now, if we're in a situation in which the report legitimately came in and Cutler doesn't testify, well, you still have the fact that the state chose to present Cutler's testimony. And a cold report is not the equivalent of live testimony. I cite an opinion by Your Honor in my brief to that effect. I think that's just fully understood that it's not the same. And we don't have. This was not an easy case. The jury was out for many hours, longer than the trial. In the end, they rejected the complainant's testimony on one charge completely, and for reasons I indicate in the brief, I mean, it was a very unusual case with a lot of problems. So to say that the difference between a written report and live testimony from the person who, from the lab that was providing the crucial link was harmless, I think is beyond anything the court can say.
I didn't say that there was no difference between the report and the testimony. I simply said, did it not attenuate the harmfulness? It may not have obviated entirely, but didn't it attenuate the harmlessness in light of the fact that the jury had already heard what was in the report?
To some extent, sure, but I don't think that's the question. I think the question is, given the harm that there was, can the court be confident that that it didn't contribute to the verdict? And I think the answer there is no. If the court has no further questions, I'm happy to reserve the balance of my time.
Nothing left.
You're out of time, but I bet Ms. Lavoie will share her rebuttal
Okay.
time with you.
All right.
I'm
Okay,
guessing.
thank you.
Try and negotiate with her, see what happens.
Okay.
Good morning. May it please the court, Amy Summers appearing on behalf of the Wayne County Prosecutor's Office for the People. This court should find that the defendant in this case has waived his right to confront the expert, Derek Cutler, by failing to file a written objection to the prosecutor's notice under Michigan Court Rule 6.202. Alternatively, this court should affirm the Court of Appeals opinion and should hold that there is no confrontation violation where an out-of-state foundational expert witness testifies in real time via two-way interactive video. Lastly, if this court does find that there is confrontation error, the error was harmless beyond a reasonable doubt, where the defendant's identity could be proven based on Cutler's report along with the other evidence. Michigan Court Rule 6.202 governs the time in which a defendant must object to the prosecutor's notice under the court rule in order to assert his confrontation right. And the defendant must do so within 14 days or his confrontation right is waived. Defendant's failure to file an objection within the 14-day period waived his right to confront Cutler, and it allowed Cutler's report to come into evidence without any testimony at all. The prosecutor relied on defendant's waiver and did not endorse Cutler. 4 days before trial and 5 months after the prosecutor had filed her notice, when defendant orally demanded Cutler's live presence, it was too late. At that point, the prosecutor could have simply proceeded with admitting Cutler's report under 6.202. But instead, the prosecutor offered to make Cutler available via video if his testimony becomes necessary, and defendant got the benefit of cross-examining him, even after he had waived the right to do so. So although it was error for the trial court to admit Cutler's video testimony over objection under Michigan Court Rule 6.006, the error was not a confrontation error because the waiver had already occurred. I would invite questions from the court at any time. We're not conceding the confrontation argument. We did fully develop that in our brief. If the court does apply the Craig analysis, it should be a balancing test where you have more on the side of reliability, as we do in this case, with this being two-way video testimony, which is, it gives an experience almost identical to in-court testimony.
Counsel, is that true?
In this case, the video testimony was via Skype, which was in real time, and it does provide two-way. In Craig, it was one-way video with a child trauma victim. And in this case, it was two-way video with an expert witness. And we're saying that expert witnesses, they don't carry the same credibility concerns as child victim witnesses. And so where you have more on the reliability side, you have the expert witness along with a two-way video, then the balance should weigh in favor of allowing the video testimony with a lesser public policy interest. So in Craig, it might not be a sufficient public policy in Craig for cost and convenience, but in a case where you have an expert witness with two-way video testimony, it might be sufficient.
Counsel, what do we, how do, you would have us, like the Court of Appeals, just evaluate the Confrontation Clause question under Craig and not confront that Crawford changed how courts think about confrontation? I mean, how would you have us address Crawford, given the question in this case?
Well, I agree with defense counsel that Craig, the vitality of Craig is in question now with Crawford, because Crawford, it allows testimonial hearsay to come into evidence when the witness is unavailable, as long as there is an opportunity for cross-examination. But I do think that Crawford...
Face-to-face cross-examination. It's
Correct.
like a hard and fast procedural rule like that. Like the world changed from Crawford, right? Like what do we do with that? I mean, we should
Correct,
deal with it, right?
but Crawford involves testimonial hearsay. In this case, the witness did testify at the trial. So that's the difference, I think. The witness testified at the trial, whereas Crawford would allow prior testimony as long as there had been that opportunity. So, but in this case, the witness did testify at the trial. And it was face-to-face, it was just not in person. So the two-way video procedure, it does provide an experience as close as you can get to in court when it comes to video testimony. And it is, I think...
So you think Crawford and all of the cases that have come after it leave room for virtual face-to-face testimony? What case allows us to get there?
Well, all of the cases involving video testimony have applied Craig, even after Crawford. But the court could distinguish Craig, I think, because this involves two-way video testimony. The U.S. Supreme Court has never addressed two-way video testimony in the context of expert witnesses. And so, but if the court does choose to apply Craig, then we're asking the court to apply it broadly and open up the exception so that it will include this balancing test where if the witness doesn't carry credibility concerns, and if we have this procedure in place that with advanced technology, it creates a virtual experience that is...
That would make us like a pioneer, right? You want this court to like be a sort of back to the future pioneer. Like
well,
go back to Craig and then expand it.
If the court does not want to reach the confrontation issue, the bottom line is that this error was harmless.
Yeah, talk about that more.
The witness, he was giving testimony regarding a DNA profile of a not yet identified donor. His report was coming into evidence no matter what under 6.202. The report was already admissible. His testimony, they never contested his testimony as far as the DNA. They never contested the DNA. At a pretrial hearing, defendant's trial counsel told the court that their defense was going to be consent. Trial counsel argued consent to the jury in both his opening and his closing. Even without Cutler's video testimony, defendant's identity would have been established with his report along with the other evidence. Catherine Maggart, who was the other DNA expert, she testified before the prosecutor even introduced Cutler's video testimony, and she also explained Cutler's conclusions at length. She explained the extraction process. She went through Cutler's report and she explained the work that Cutler did as well. So her testimony corroborated everything that Cutler testified to and everything that was in his report. So his testimony was cumulative. And so without even taking out Cutler's video testimony, based on the report and based on all of the other evidence, the outcome would have been the same. So the error was harmless if the court does find error.
But aren't there several decisions of the U.S. Supreme Court that suggest that the kind of expert report that you're alluding to here is generally tantamount to in-court testimony and functionally identical to such testimony, therefore implicating the Sixth Amendment's Confrontation Clause. That's Melendez-Diaz, Bullcoming versus New Mexico. A forensic laboratory report is a testimonial statement implicating the Confrontation Clause. So I understand, and I asked a question of opposing counsel concerning the impact upon harmfulness of the admission of the laboratory report. But I guess my question is, was the lab report permissibly allowed in the first place?
Yes, it was, because under 6.202, defendant waived the report by failing to object to the notice. And the court actually ruled on that at the pretrial hearing on May 20th that the report was coming in.
And defendant didn't object within, what, 14 days?
Correct.
Was there any sense that the report was conditioned upon the actual testimony of Cutler?
No, Your Honor. Justice Markman, the report is admissible in lieu of testimony under 6.202. That's what the rule says.
Well, what do you make of the implications of Melendez-Diaz and Bullcoming?
Melendez-Diaz, you're correct. It does say that lab reports are testimonial. And if defendant here had not waived the report, it might be different in this case, but defendant did waive the report.
So waiving your objection to the rule, you also waive your constitutional rights?
You waive the right to confront the witness if you don't object under 6.202. The report's coming in without any testimony.
Yeah, that's the question, though. Can we, by court rule, have people waive constitutional rights?
That's what Melendez-Diaz says. It says that notice and demand statutes and procedures, they govern the timing in which a defendant must assert the right, and in Melendez-Diaz, they found that to be constitutional. Making the defendant assert his right within a certain time frame was constitutional under Melendez-Diaz, and this court actually adopted 6.202 in response to Melendez-Diaz.
Well, not to make analysis of this case any more convoluted, concerning waiver, did you not waive the waiver argument? You didn't raise it before the Court of Appeals, and even more, you didn't raise it in response to defendant's application for leave to appeal in this court. Why should we allow you to raise it at this relatively late juncture?
Your Honor, we did not file a brief in the Court of Appeals, regrettably, and the waiver argument is an additional grounds that we're raising now in order to support the judgment below. And the general rule is that the appellee can defend the judgment on any basis that's supported by the record. We do think it's the correct legal analysis. We're bringing it to the court now in our supplemental brief on the merits. They had an opportunity to respond to it. This court in People v. McGraw affirmed the principle that an appellee is not required to file a cross appeal in order to raise a waiver argument. And in People v. McGraw, this court just said that the appellee should raise the argument at some point in order to have it be considered. In that case, the prosecutor had never raised it, so the prosecutor had abandoned it, but this court said the appellee just needs to raise the waiver argument at some point. They did object on confrontation grounds under 6.006, and so it is questionable whether that preserved the testimony portion of the confrontation, but as far as the report, we're saying it's waived under 6.202.
And did defendant have its first opportunity to respond to that argument in this court?
In the supplemental brief, yes.
Okay, thank you.
If there are no further questions.
I don't see any.
Okay.
Thank you very much.
Thank you.
I just had a couple things, and if I have extra rebuttal, I'd happily share with Professor Friedman. But I would just note that this is a very similar situation that the U.S. Supreme Court looked at in Lee versus Kemna. In that case, the prosecution, late into the game, made an argument that a defendant had not followed or substantially complied with a rule that required a written objection to an adjournment. The Supreme Court found that the oral motion there was sufficient to substantially comply with the rule. They took note of the belated assertion of the rule's writing requirement and ultimately found that the failure to strictly comply did not bar the defendant's federal claim. This was not an intentional relinquishment of a right. This was not a waiver. Counsel at the hearing indicated he wanted the witnesses to appear in court. This issue has not been waived, and it is our position in addressing a question that Justice Markman posed that the report would not have been admissible absent Cutler's testimony. We would have had a Melendez-Diaz problem. Catherine Maggart wouldn't have been allowed to testify because we would have had a surrogate expert problem that the Supreme Court addressed in Bullcoming. Without his testimony, there would not have been evidence to support the DNA. And finally, the prosecution here argues for a balancing test, making arguments about reliability. This is the exact standard and analysis that the U.S. Supreme Court had done in Ohio versus Roberts that was abrogated by Crawford. And there is language specifically in Crawford that talks about no open-ended exceptions to violations of confrontation. We would ask that this court find that this was preserved constitutional error and that it was not harmless beyond a reasonable doubt.
I have a little time?
Yeah, you have 6 minutes and 4.
Oh my goodness.
Yeah.
I won't,
Sure.
I won't use it. First, I would have thought that the email notice was sufficient to state an objection. If not, for some reason that I'm not aware of, it was an objection, the 14-day limit is still defeasible. It's not an absolute limit, and it should be excused for good cause. And I would have thought, well, gee, I did state an objection by email. Would have been good cause. I asked Ms. Summers for the copy of the email. Well, nobody seems to be able to find the email. So, but it's acknowledged that it was sent. And when I said that, and I think it was clear that when I said that the error would be attenuated, not eliminated by any means, that was if the report was legitimately in. And I don't think we can tell that. The only ways the court could avoid reaching the confrontation issue would be to reverse or to hold the error harmless beyond a reasonable doubt, and I think it just clearly is not it's not harmless beyond a reasonable doubt, and I think the confrontation clause violation is so clear. I think it would be really useful for this court to state that as as the highest court in the state, not to allow the Court of Appeals opinion to stand.
Do you think that jurisprudence leaves any room for us to be pioneers in video confrontation? Do you think there's any room, as your friend on the other side argued?
I don't think there's any room. I don't think it's appropriate. I think it would be a mistaken endeavor. I think the consensus of courts around the nation is quite clear. Certainly, that in a case like this, there's nothing to be done. This certainly would be the wrong case if you decided that we've really got to do it in compelling cases. Wait for a compelling case. But I think bad effort, wrong setting for it. Maggart could not. I think there's room for the court to adjust its rules with respect to hearsay and be a pioneer, but that's a different matter.
We'll talk about that in a
minute. Yeah, okay, yeah.
Can I ask you,
yes.
Is there any greater or lesser authority today in light of U.S. Supreme Court constitutional law to have the courtroom configured in particular ways to protect young witnesses from the scrutiny of their alleged sexual abusers and such? Is that distinctive from video conferencing where somebody's 1,000 miles away? Or should we look upon all those things as being part and parcel of the same basic constitutional precept that defendants have the right to look eye to eye at the witnesses?
Well, that's a hard question. I mean, I think there is that right. I mean, the Supreme Court hasn't really addressed the issue since Craig, which still stands. I think certain things can be done. I think it's not so much a matter of courtroom architecture as preparation of the child.
Is that one way? I'm just asking
Yes.
this, based on your obvious expertise in this area, but is that a possible avenue to harmonizing Crawford and Craig?
I don't think so. I think if ultimately we were satisfied that remote confrontation were sufficient, that would be one matter. I think, actually, and it's something that I care a great deal about and have worked on a lot. I think ultimately the way of harmonizing is to recognize that very young children are not really acting as witnesses at all, because they don't have the cognitive ability or the maturity to understand the witnessing function. And I think
Which would allow children to testify without cross-examination?
I wouldn't even call it testifying. I would say that they're sources of evidence without being witnesses, and the defendant should have a right to have them examined, but not by an attorney in court. That's why I've written with one of the world's great developmental psychologists an article called "The Child Quasi-Witness," and that's what I think is the harmonization that would be possible. And maybe in another case, maybe there's room for pioneering there. One other point I wanted to make was that Maggart couldn't have corroborated Cutler. I mean, she might have referred to his evidence in advance, but it's Sorensen that's the source of that identification, of that profile, rather. She's just saying these two profiles are the same. She can't speak to what happened in the Sorensen lab. And I think the court understands the waiver argument made by the prosecution, and I think I won't have anything more to say about that. So unless there are any further questions.
Thank you very much.
Thank you.
The case will be submitted.